This is a list of all the sections in Chapter 11. We won't discuss the sections in gray font. We'll touch upon the sections in black font, and we'll spend most of our time focusing on sections 1101 and 1105. The first sentence of this chapter tells us that Chapter 11 and its appendices shall control the design and construction of facilities for accessibility to persons with physical disabilities. This doesn't mean that accessibility is only discussed in Chapter 11. For example, Chapter 10, which discusses means of egress, also include some requirements. And the same is true of Chapter 30. If a new building is built, it must be accessible. Where does the code say that? That's 1101.2. So what if you're just renovating or altering a building? We'll look at that in the next couple of slides. Design and construction must follow this code and the 2009 version of ICC A117.1. This is sometimes called ANSI 117.1. ICC stands for International Code Council, and ANSI stands for American National Standards Institute. There are special provisions for prior code buildings. Accessibility provisions apply to alterations, minor alterations, and change of use or occupancy. All of the highlighted terms on this slide are either defined or described further in code. Ordinary repairs is a defined term in code also. Ordinary repairs and certain residential occupancies under certain conditions don't need to comply with this provision. The administrative code tells us that even if your project is allowed to comply with the 1968 or 1938 code, when it comes to accessibility, you must comply with 2014 Building Code, Chapter 11, and the 2009 ICC A117.1. As a reminder, minor alterations don't affect the health or fire or structural safety of occupants. This is an important slide, so pay attention to this one. Accessible features and construction governed by this chapter shall be provided in 3 instances. Let's focus on 1 and 2. Number 1, accessibility requirements apply to the entire building where a change is made in the main use or dominant occupancy of the building. Number 2 tells us that accessibility requirements apply throughout a space, including the immediate entrance to that space, where an alteration is made that is either a change in occupancy or a change in the zoning use group. So number 2 is telling us that we need to check 2014 Building Code Chapter 3, which is titled Use and Occupancy Classification, and or we need to check the applicable sections of the zoning resolution. Item 2.1 gets even more specific. If the door to a space is within 1.5 feet from the sidewalk grade and the project meets the conditions of item 2, then that entrance must be accessible. We'll get into some examples soon. This slide is just a reminder that when a project exceeds a certain cost threshold and modifications are made near or at the entrance, that entrance must be accessible. Let me try to summarize what we've learned so far. When is accessibility at an entrance required? At all entrances of new buildings, alteration projects that exceed a certain cost threshold, and when there is a change of main use or dominant occupancy of the building. Certain alteration projects trigger accessible entrance requirements. This occurs when there is a change of occupancy or use to a portion of the building. This also occurs when there is a partial alteration, where work is being done to a part of the building. Chapter 11 defines entrances this way. A service entrance is an entrance solely for delivery of goods or services. A restricted entrance is one that is made available for public use, but on a controlled basis, and that is not a service entrance. A public entrance is an entrance that is not a service entrance. So if you're reviewing an entrance door on a set of plans, work your way down these definitions. Restricted and public entrances both serve the public in some way. However, a service entrance does not serve the public unless it's the only entrance to a space. That is stated in BC 1105.1, exception 2. Section 1105.1 tells us that all public entrances must be accessible. There are 3 exceptions to this provision that I'll briefly mention. Exception 1 basically says if the entrance is in an area that is not required to be accessible, then it doesn't have to be accessible. Exception 2 says that loading and service entrances that are not the only entrance to a building or tenant space do not need to be accessible. That means there's probably another entrance that is required to be accessible. Exception 3 says that revolving doors, revolving gates, or turnstiles don't need to be accessible as long as there is any accessible entrance nearby. 1105.1 also includes requirements for accessible entrances at parking garage entrances and entrances from tunnels or elevated walkways. All restricted entrances must be accessible. A service entrance must be accessible if it is the only entrance to a building. An accessible entrance needs to be provided to all non-residential occupancy tenants as indicated in 1105.1.6. 1105.1.6.1 applies to hotels and residences that are required to be accessible. So take a look at this image. The door on the left is a public entrance that is 6 inches above the sidewalk. The door on the right is a public entrance that is 24 inches above the sidewalk. A change of occupancy is proposed to the space served by the doors. Must both doors be made accessible given those conditions? One door or neither door? It's door number 1, that is, the door on the left must be made accessible per 1101.3.1, which was discussed on slide 14 or 15. The door on the right is not required to be accessible because it is more than 18 inches above the sidewalk. For information about exterior ramps and stairways, you can check out BC 1026. Lifts are only permitted in certain circumstances. Lifts are used when the construction of the floor makes it difficult to accomplish a means of an accessible entrance. If a lift is used, it must not reduce the minimum required egress width along the path of travel. The lift must be installed in accordance with ASME 18.1. ASME stands for American Society of Mechanical Engineers. A chairlift, as seen on the right of slide 24, is not an acceptable way to provide an accessible entrance. It is also not an acceptable form of accessible means of egress. You can read a little more about that in BC 1007.5. We'll also briefly discuss a bulletin related to lifts later. On this slide, slide 26, there's a bulletin 2009-2000-025 that you can see on slide 25. This bulletin is related to accessible entrances. The main purpose of the bulletin is to clarify when a new or amended certificate of occupancy is not needed. More specifically, this bulletin only applies to the certificate of occupancy process as it relates to a small existing individual establishment that is changing from business to mercantile or mercantile to business. The bulletin lists items 1 through 6, and all of those items have to comply in order to not have to change the C of O. On this slide, slide 26, you see those items 1 through 6 are paraphrased. Item 1 states that the alteration has to be within the same zoning use group. Item 2 states that this does not apply to assembly occupancies. If you were wondering what counts as a small establishment, like I was when I first read this bulletin, know that it means less than 75 occupants, which means it's not an assembly occupancy. Item 3 states that the space of the alteration is located at or near the ground floor. We say at or near the ground floor because there are some buildings where the space may be a little bit above or a little bit below ground level, and we want to make sure that we include those spaces in this item. Item 4 states that the portion of the establishment which is being altered complies or is made to comply with any other requirements that would be applicable to alteration, including but not limited to accessibility requirements, entrances, toilet rooms, etc. This means that an accessible entrance is required if the scope of work mandates that the alteration comply with BC Chapter 11. Item 5 states that there are no change in required exits, except that exit doors can be made bigger. And item 6 states that there is no change in the live load. Let's talk about a couple of different scenarios now. You're looking at an image on slide 27 of an existing building. This picture is from a couple of years ago. An applicant filed a job around 2016. It was an Alt 1 job. No change to the zoning use group 6 was proposed. A change from a commercial occupancy group to an assembly occupancy group is proposed. Based on the information provided, is an accessible entrance required? Yes. This building went from some kind of souvenir or clothing store to an eating establishment or restaurant that you may know. Slide 29 shows the first floor plan of this restaurant. It's a bit small, but we'll get what we need to know just by looking at the smaller image. Let's start by talking about the entrance, which is circled in yellow at the right of the screen. No level change is shown at the double doors that open to the sidewalk at grade. The dark gray path you see here going throughout the floor plan shows proposed circulation through the space. It's also an accessible route. You'll also notice an elevator, a passenger elevator, and we'll take a look at portions of the upper floor plans to see that the elevator goes all the way to the occupied room. Back here to the left of the screen, you'll notice a LULA elevator. LULA stands for Limited Use, Limited Access. This is found in the food preparation area of this particular space. And this specific LULA may be intended for moving food, not occupants. But whatever the case, for the purposes of this presentation and our focus, the entrance looks good. Here's a cropped image of the second floor plan of that same building, just to show you that the dark gray path of the accessible route continues to the second floor. Requirements for an accessible route are found in BC 1007. This plan also happens to indicate clearances for the bathroom, and you can see an accessibility symbol for certain areas of seating where accessible seating is required. This is a cropped image of the third floor plan. And finally, we see the roof where the accessible route and seating are also indicated. On slide 32, we have another example. Imagine you have an existing building with no proposed change of occupancy or zoning use group. The applicant proposes to remove the existing storefront vestibule and replace it with a new one. The review is requested under the 1968 Building Code. Is an accessible entrance required? Yes, an accessible entrance is required based on the Administrative Code 28-101.4.3, item 5 on slide 12 or 13. And BC 1101.3.2, item 2, slide 16. Here we see an elevation of the new ramp and vestibule doors. On slide 35, we have a plan view of the area. In order to be a compliant accessible ramp, you need to take a closer look at the dimensions indicated to see how they compare with the requirements. You may not necessarily be able to see the dimensions here, but I just want to get across that you need to take a closer look at the dimensions on whatever project you're reviewing. Those dimensional requirements are found in BC 1010. Some of those requirements include a minimum landing that is 60 inches long. The maximum slope is 1 to 12. That's rise over run. Note that ramps can be a part of an accessible means of egress. Keep in mind that the minimum clear width of a door opening is 32 inches. The 32-inch width is measured with the door open at a 90-degree angle from the door stop to the face of the door. We've talked about ramps and LULA lifts up to this point. BC 1109.6, as shown on slide 38, is just a reminder that an elevator can be used as accessible route or entrance. In BC 3001.3, LULA lifts and platforms are mentioned. LULA lifts and platform lifts are not the same thing. Buildings Bulletin 2016-008 clarifies where wheelchair platform lifts may be installed in a prior code building. Part 1 describes where the use of a wheelchair platform is not permitted. Part 2 describes where it is permitted. Part 3 talks about waivers which can be pursued through the Mayor's Office of People with Disabilities, or MOPD. Part 4 states that 1- and 2-family buildings can utilize these lifts. We're going to talk about one more scenario related to accessible entrances. The scenario is also related to these code provisions. BC 3202.2.2.1 states that when a building erected prior to December 6, 1969 is altered to provide access to individuals who use wheelchairs, then a ramp that is constructed to provide that access, with the approval of the commissioner, may project beyond the street line for a distance of not more than 44 inches. BC 3201.9 says that if you cannot meet that 44-inch limitation, you must contact DOT for their approval. So here we have our third and final example. The applicant has filed an alteration type 1 application for an existing building and is proposing a change from commercial that's COM under the 1938 Building Code to a business occupancy, which is B under the 2014 Building Code. The review is requested under the 1968 Building Code. So the applicant submitted an AI1 form, and he explained that DOT revocable consent is not required for a new ramp because he states that the new ramp does not project past the street line for more than 44 inches. So the applicant believes that because his ramp doesn't go more than 44 inches past the street line, then there's no need to go to the Department of Transportation for any approval or acceptance. Is that correct? Before I get to the answer, I'll show you some photos here. The top 3 images are photos of the building at an angle. The photo on the right was the original configuration. I'm sorry, the photo on the left is, I'm a little confused. So the photo on the left is the original configuration. The photo on the right shows the new stair and ramp. You can't really see the ramp, it's going away from us, but you see it better here in the floor plan. You may or may not be able to see the dimensions, but the width of the ramp is 3'8", which is 42 inches, 44 inches. And you've got a stair going in the other direction. So that floor plan gives us a better idea of what we're looking at. And from the floor plan, we have a better idea of whether the project complies with the provision. If evidence can be provided that the building was erected prior to the date indicated in BC 3202.2.2.1, and if the width of the ramp is 44 inches or less, we're seeing that it's 44 in this floor plan, then compliance has been achieved and DOT approval is not required. So again, if the applicant provides official documentation, such as the certificate of occupancy that indicates that the building existed and was erected prior to 68, and specifically prior to the date in the provision that we just read, and the ramp is 44 inches wide or less, then this is okay. Signage is discussed in BC 1110. Signs have to be able to show the user the route to the nearest accessible element. This section indicates the requirements and where those signs need to be provided. We're only, again, touching on the topic of entrance accessibility, but this section is a good place to start when discussing signage for accessibility. We are continuing to look at BC 1110, where it's emphasized that the signage must direct a user towards the correct entrance when it comes to accessibility. So if you approach a storefront and it's not easily understood where that entrance is, the applicant must review this section to ensure that they can direct the user to the appropriate entrance. The last couple of slides we have here are an appendix. They are not the main point or topic of our presentation, but they include information that you should know as you design or review your project for accessibility and clearances. So slide 46 discusses some of the common components of accessible public entrances. These images are taken out of the ICC ANSI A117.1 2009 version. This slide continues to show you some of the typical door maneuvering clearances that are required. Two doors in a series need certain requirements regarding accessibility in order for someone to be able to change direction within a vestibule. Here we have the clear width and is accessible route indicated. And slide 50 gets into more details about LULAs. They're allowed a maximum rise of 25 feet, and they cannot serve more than 3 contiguous floors. New construction LULA elevators are permitted in specific cases. The wheelchair lift is permitted to be a part of a required accessible route where either a wheelchair lift is permitted or a private residence elevator is permitted, and they can be a part of a required accessible route in certain places where religious services are held and in multi-level buildings according to provision 1104.4. Prior code buildings, LULA elevators are permitted only where buildings are less than 10,000 square feet and where elevators are not otherwise required by Chapter 30. 1109.7 provides further information about lifts. The image again is from the ICC standard. Platform wheelchair lifts are generally not permitted to be a part of a required accessible route in new construction. There are some cases where lifts for accessibility are allowed, and those are indicated in the provision. And this slide is just here to remind you that the current code requirements in the New York City Building Code were based in part on previous local laws. That's Local Law 58 and 47. These requirements of the local laws are now incorporated within the current code. But as we stated earlier in the presentation, accessibility must comply with the New York City Building Code and the ANSI requirements when it comes to storefront entrances. At this point, we'll see if we can answer any questions you have at this time that we haven't been able to answer through the presentation. And I just want to let you know that if for some reason we can't get to your question, or you feel you would like it to be reviewed again, you should consider emailing constructioncodes@buildings.nyc.gov. I'll say it again, it's constructioncodes@buildings.nyc.gov. This is an email service that cannot provide project-specific comments, but we can attempt to clarify code provisions. So if you have a code provision that is causing some confusion and you want some clarification, consider emailing that address to get general clarification about a provision. You can also see that email address at the Contact Us portion of the DOB website. All right, so we have a question. How are service lifts handled? I will assume by service lifts, you are talking about elevators and conveyor systems. I would recommend that you review Appendix K and Chapter 30. Chapter 30 of the Building Code has to do with elevators and conveying systems. All right. So my colleague Maria has highlighted another question for discussion. Thank you, Maria. If a building has more than one door, which is less than 18 inches above the sidewalk, do both doors need to be made accessible? Let me jump back to our earlier slide where I had an image of two doors that were serving one space. Right, so let me read that question again. If a building has more than one door, which is less than 18 inches above the sidewalk, do both doors need to be made accessible? So one of the first things you should determine is what type of door each door is. So we had discussed the definitions of entrances on another slide. In the example that I had given earlier on slide 21, I clearly stated that both doors were public entrances. So if the question is, if the building has more than one door and both doors are public entrances, do they need to be made accessible? The answer is yes, because both doors serve the public and do not meet the threshold to not provide accessibility. So I would recommend that you look at your specific project and assess what type of entrance each entrance is, and review both of the provisions in order to determine whether that applies to your project. But based on the information I've kind of pulled together and assumed both entrances would require accessibility. All right, so we have a question that we've pulled up. When would the updated version of the NYC construction codes be released, along with the updated Chapter 11? So the construction code revision process is ongoing. The public is made aware of any updates through the New York City Council, because part of the process of reviewing and revising the construction codes includes giving the revision to the New York City Council. So anything that is available to the public, you would have a good source of information is to see what is available at the New York City Council website. Any updates that are made to Chapter 11 will be done through that governmental process. So here's another question. BB 2009-0225. Why is small less than 75 occupants? PA, place of assembly, will only be triggered, let's say in a B occupancy, if 75 persons or more are in the same room. Depending on the occupancy occupancy load will vary, even though floor area remains the same. I'd like to address that in the indication that, as we saw on a previous slide and as indicated in that bulletin only applies to places that are not places of assembly. And if you want to discuss something that is not a place of assembly, then that bulletin will not provide you an answer. If you wish, you can state your question in that general way and send it to constructioncodes@buildings.nyc.gov, and we'll be able to do a little research and let you know what may apply in that situation. And of course, if you ever feel that your project or conditions are unique and you cannot meet code requirements, there's a practical difficulty, and you propose something equally safe or better than code requirements, you can submit a CCD1 if necessary. Okay, we have one question that was brought up. If a building does not have a CFO, but it was built in 1926, shall LNO, a letter of no objection, be obtained so that DOT does not need to be involved? I would recommend that Well, first I'll say that to get a C of O is always a good idea, because a C of O for a building establishes certain legal requirements for a building. If you choose to get an L&O that says that the building was built in 1926, if you can do that, then that could be one way of establishing that the building was erected prior to December 6, 1969, or the date that was indicated in the provision in BC 3202. And this could be one way to establish the date that the building was built. But remember that that's not the only thing you have to establish to avoid going to DOT. The ramp itself has to be less than 44 inches, 44 inches or less from away from the property line. All right, so again, if I have not gotten to your question, you still have a question, you still want an answer, please consider emailing constructioncodes@buildings.nyc.gov. You can also see that email address at the Contact Us portion of the DOB website. We'll try to answer your question in the sense that we'll attempt to clarify any questions you have about code provisions there. Thank you for your attendance to this storefront accessibility presentation. Hope it was helpful. Thank you very much. This concludes the presentation. Bye-bye.